Okay, we continue our lesson with the next term, CFR. CFR means delivered at the port of destination, unloading cost to be agreed. But before anything, the disclaimer. I'm not a lawyer and lessons given are not legal advice. I'm just sharing my professional knowledge and experiences earned over 2 decades. The quotes we use from the Incoterms 2020 book are all the intellectual property of ICC, International Chamber of Commerce, whom I thank for their effort and perseverance in updating and revising the terms and also permitting us to use the quotes. Okay, as you can see in the diagram, you see that the seller is responsible to deliver the goods on board. So the delivery point here is on board, but the transportation cost until the port of destination is on the seller. The insurance, as you can see, the line is empty, means that insurance is not a liability on neither of the parties. And it means that the insurance policy is not one of the shipping documents required by the banks in the case of a letter of credit. Custom freight requires the seller to place the goods on board the vessel contracted by themselves. From that point on, the risk of loss or damage to the goods transfers to the buyer, but the shipping cost is on the seller until port of destination. This is the definition in the book. A1. General obligations. In each of the 11 rules, the seller must provide the goods and their commercial invoice as required by the contract of sale and any other evidence of conformity, such as an analysis certificate or weighbridge document, etc., that might be relevant and specified in the contract. Each of the rules also provides that any document can be in paper or electronic form as agreed to in the contract. Or if the contract makes no mention of this, then as is customary. The rules do not define what electronic form is. It can be anything from a PDF file to blockchain or some format yet to be developed in the future. B1. General obligations. In each of the rules, the buyer must pay the price of the goods as stated in the contract of sale. The rules do not refer to when the payment is to be made, before shipment, immediately after shipment, 30 days after shipment, half now and half later, or whatever, or how it is to be paid. Prepayment, against any mail of copy documents, on presentation of documents to a bank under a letter of credit, or other arrangements. These matters should be specified in the contract. As we discussed before, when we talk about the cost and the price of the goods, we must understand that in CFR, the cost of shipping is added to the invoice. So according to the definition, cost means the price of the goods and freight means the shipping cost, which will be paid by the buyer to the seller. Something to be mentioned here is that in all documents, the price of goods and the freight charge must be separately stipulated in the documents. A2. Delivery. The seller delivers by placing the goods on board the vessel on the agreed date, or within the agreed period, or if there is no such time notified, then at the end of that period, and in the manner customary at the port. Most importantly, delivery occurs when the seller loads the goods onto the vessel, not when the vessel reaches the destination port. Many people, by mistake, when they use customs freight for their transactions, they think that because the cost of the freight is on the seller until the port of destination, also the risk of any damage is on the seller too. But buyers must be careful that this is just the freight cost which is on the seller, not the responsibility. So they have to take care about the insurance or any measures they have to take in order to protect their merchandise. B2. Delivery. The buyer must not only take the delivery of the goods when the seller has delivered them on board the vessel, but also receive them from the carrier at the named destination port. Most importantly, delivery occurs when the goods are released from the seller's direct control, not when the goods reach the destination. The main difference in wording to FOB, With CFR and CIF, reference to the vessel being nominated by the buyer is absent, as is reference to the buyer nominating a loading point within the load port. The contract for carriage and cost implications are dealt with in other articles. A3. Transfer of risk. In all the rules, the seller bears all risks of loss or damage to the goods until they have been delivered in accordance with A2 described above. The exception is loss or damage in circumstances described in B3 below, which varies dependent on the buyer's role in B2. B3. Transfer of risk. The buyer bears all risks of loss or damage to the goods once the seller has delivered them as described in A2. If the buyer fails to inform the seller about the destination port or the point within that destination port, then the seller is unable to deliver under A2 and the buyer bears the risk of loss or damage to the goods from the agreed date or at the end of the agreed period. We must always keep in mind that apart from the terms and conditions stipulated in the definition of a term, if each party fails to handle the parts of the process which they are responsible for, then the rules are violated and then there will be circumstances which they have to bear. A4. Carriage. The seller must arrange or procure in case of a string sale a contract for the carriage of the goods from the agreed point of delivery in A2 to the named port of destination, or if agreed, to any point, quay or wharf in that port. The contract of carriage must be made on usual terms which are appropriate to the type of goods and by a vessel normally used for transporting the type of goods by the usual route, often agreed in the contract of sale at the seller's cost. B4. Carriage. The buyer has no obligation to the seller to arrange a contract of carriage. String sale is a kind of transaction in which there is one seller at the beginning of the string and then the product is sold through this string from one seller to the other buyer. I mean, the buyer to the first seller may be the seller to the second buyer, and this goes on until the goods reach the final destination. This is called a string sale. So in case of a string sale, when we talk about CFR, the carriage contract to cover all the string sale is on the seller. A5. Insurance. The seller does not have the risk beyond the delivery point, so it has no obligation to the buyer to arrange a contract of insurance. However, if the buyer requests at its risk and cost, the seller must provide the buyer with information in its possession that the buyer needs to arrange its insurance. B5. Insurance. Despite having the risk of loss or damage to the goods from the delivery point, the buyer does not have an obligation to the seller to insure the goods. Whether the buyer chooses to insure the goods or bear the risk themselves is entirely their choice. Yes, as I told you before, in many cases, buyers misunderstand or misread the situation, and they think that the same as the freight charge, the responsibility of any damage or anything that happens to the merchandise will be on the seller while the vessel is on the ocean. But in order to remind again, the buyers must always be aware of this and buy insurance for their own merchandise. Even if it is a string sale, the first buyer must buy the insurance until the end of the way. A6. Delivery transport document. The seller at its own cost must provide the buyer with the usual transport document covering transport to the agreed port of destination. The transport document must cover the contracted goods within the agreed period of shipment. If it is agreed, then this document must enable the buyer to claim the goods from the carrier at the named place of destination, and in a string sale enable the buyer to sell the goods in transit to a subsequent buyer by transferring that document. B6. Delivery transport document. The buyer must accept the transport document provided by the seller if it is in conformity with the contract between them. Actually, CFR is one of those accepted terms by the seller because the seller makes the contract of carriage by himself, and it is one of the best terms for a letter of credit because there is no risk that the buyer rejects to provide an onboard bill of lading to the seller to collect the amount of letter of credit. A7. Export-import clearance. Where applicable, the seller must at its own risk and expense carry out all export clearance formalities required by the country of export, such as licenses or permits, security clearance for export, pre-shipment inspection, and any other authorizations or approvals. The seller has no obligation to arrange any transit import clearances. However, if the buyer requests at its own risk and cost, the seller must assist in obtaining any documents and/or information which relate to formalities required by the country of transit or import, such as permits or licenses, security clearance for transit or import, pre-shipment inspections required by the transit or import authorities, and any other official authorizations or approvals. In string sales especially, when we talk about the transit of the goods through different customs, since the seller has enough information and has enough resources of documents for any transit or import formalities, provided that the buyer accepts the cost and the risk, the seller must assist the buyer to handle these parts of the process. B7. Export-import clearance. Where applicable, the buyer must assist the seller at the seller's request, risk and cost, in obtaining any documents and/or information needed for all export-related formalities required by the country of export. Where applicable, the buyer must carry out and pay for all formalities required by any country of transit and the country of import. These include licenses and permits required for transit, import licenses and permits required for import, import clearance, security clearance for transit and import, pre-shipment inspection, and any other official authorizations and approvals. They are the buyer's responsibility because they occur after delivery by the seller. At first glance, it might seem strange that both seller and buyer have responsibility for pre-shipment inspections. To clarify, the seller is responsible if it is a requirement of the country of export, and the buyer is responsible if it is a requirement of the country of transit or import. As we have mentioned before, for many products, there are some certificates needed to do the export clearance in the country of origin. So if such document is needed, the buyer must assist the seller, but at the seller's cost and risk. But as we mentioned at the end of the paragraph, if this requirement is by the country of export, the costs will be on the seller, and if it's a requirement by the country of import, the cost will be on the buyer. A8. Checking, packaging, marking. In all rules, the seller must pay the costs of any checking operations which are necessary for delivering the goods, such as checking quality, measuring the goods and or packaging, weighing, counting the goods and or packaging. The seller must also package the good at its own cost, unless it is usual for the trade of the goods that they are sold unpackaged, such as in the case of bulk goods. The seller must also take into account the transport of the goods and package them appropriately, unless the parties have agreed in their contract that goods be packaged or marked in a specific manner. In case the buyer does not trust the seller and wants an international inspection company to check the goods as for the quality and quantity, the cost will be on the buyer. But the basic checking and counting and these sort of things will be on the seller. B8. Checking, packaging, marking. In all rules, there is no obligation from the buyer to the seller as regards packaging and marking. There can in practice, however, be agreed exceptions, such as when the buyer provides the seller with labels, logos, and similar. As we have told you before, in many cases, the buyers ask the sellers to provide products in their own designed and marked and branded packings, and this is an exception and an extra requirement from the buyer. So, any difficulty emerging from this scenario will be on the buyer. I mean, if the buyer fails to provide these sort of things, including the packaging, labels, blah blah, any delay caused by this failure will be on the buyer, and the buyer will pay for any demurrage or maybe any storage costs, etc. A9, allocation of costs. The seller must pay all costs until the goods have been delivered under A2 on board the vessel, except any costs the buyer must pay as stated in B9. The seller must pay the cost of loading the goods on board the vessel, the freight costs, and any transport-related security costs. If the contract of carriage includes transit costs and or unloading at the discharge port, then these costs are for the seller. As for the unloading costs, it is to be agreed in the contract of sale. In many cases, the cost of unloading can be on the buyer or the seller, so it depends on the agreement between two parties. But there is a point which I have to mention. If the merchandise reaches the port of destination and the buyer for any reason walks away from the deal, then any kind of demurrage will be on the seller, and the shipping company, since they have made the contract with the seller, will sue the seller for these payments, and the seller will finally pay these costs. So when dealing with the down payment amount, you have to keep these in your mind, that if such scenario happens, you will lose a lot of money. A wise seller would buy a contingency insurance to cover these kind of scenarios. The seller has to pay any costs involved in providing the usual proof that the goods have been delivered. So if the contract between the parties states that proof as being a bill of lading, then any document fee is for the seller. In the case only of CIF, the seller pays the cost of insurance covering the buyer's risk. The seller pays any costs, export duties and taxes, where applicable, related to export clearance. If the buyer is requested by the seller to provide information or documents to assist the seller in their export formalities, then the seller must pay the buyer for these costs. In a string sale, as we said, the buyer to the first seller will be the seller to the second buyer. So in these cases, the same relation will happen. B9, allocation of costs. The buyer must pay the seller all costs relating to the goods from when they have been delivered, other than those payable by the seller. If the seller has been requested by the buyer to provide assistance in obtaining information or documents needed for the buyer to effect insurance, only in the case of CFR, and transit and import clearance, then the buyer must reimburse the seller's costs. Where applicable, the buyer pays any duties, taxes, and other costs for transit or import clearance. Additionally, and provided the seller has advised that the goods have been clearly identified as the goods under the contract, the buyer pays any additional cost incurred if the buyer fails to give notice, if the parties have agreed in the contract that the buyer is entitled to determine the time for shipping the goods and or the point of receiving the goods in the port of destination. A10, notices. The seller must give the buyer notice that the goods have been delivered, meaning loaded on the board the vessel. The seller must also give the buyer any notice required by the buyer so that the buyer can receive the goods. What that notice is will be agreed in the sales contract and might well also refer to conditions contained in the charter party, the contract of carriage if relevant. B10, notices. If the parties agree in the contract that the buyer is entitled to determine the time for the seller to ship the goods, and possibly more importantly, the point within the named port of destination where it will receive the goods, the buyer must give the seller sufficient notice. The contract will usually detail how much notice is to be given. As we mentioned before, notices play a very important role in international business. If a party fails to give a notice, a vital notice at the point where needed, then any cost emerging from this failure will be on that party. Points to keep in mind. CFR is a widely used term and also a good one for cross-ocean shipments, but you have to be careful about some items. 1. Many buyers think, due to lack of information, that in CFR the risk of damage is transferred to them in parallel with the cost transfer. This risk of damage, as said before, is transferred to the buyer when the goods go on board in the port of origin. 2. In CFR, there is no obligation on the seller or buyer to buy an insurance for the merchandise to cover the risk of damage. But for two sides of the deal, there are some points to mention about this issue. 2.1. Consider the case that the seller sends the goods on a vessel which is arranged by itself. In this case, the carrier corresponds with the seller in case of any problem because it is actually the seller who has contracted it. If the buyer walks away from the deal for any reason, all demurrage and THC will be obtained from the seller. So it is advised to sellers to buy a contingency insurance to cover such potential incurred costs. 3. Please define the port of destination precisely and not the harbor city only, since there may be several ports in one city. In Istanbul, for instance, there are 6 ports with customs next to them. 4. The unloading cost in the port of destination has to be agreed in the contract. 5. The THC, terminal handling charges, in the port of loading is on the seller, but these costs at the port of destination must be agreed. 6. Any demurrage cost at the port of loading is on the seller as they happen before the delivery. 7. Both the seller and buyer must exactly know how to insure the goods so that in case of any negligence by their agents during loading and unloading, they can claim the damage from the insurance company. 8. According to Incoterms 2020, this term is not suitable for containerized goods, as we said about FOB. But if you are willing to use this term as buyer, you must be serious about the type of packing, since any damage in the loading stage will cause a controversial legal case, which will be hard to finalize. Something I have to mention here is that the seller is not aware of the situation of your country. So if you see that the unloading will cause any damage to the merchandise packaged in the standard export packaging, so you can ask your seller to provide a stronger packaging for your products. 9. In all terms, take on as much as the term says, not more, not less. As an example, consider you want to sell on CFR basis. The letter of credit is opened based on a PI in which you have mentioned the cost and freight of the goods. The buyer finds a cheaper deal for the ocean transport and offers to take the transportation without making changes in the LC. This is too dangerous because the goods are under the buyer's control while you are responsible for them. 10. This term is a good choice for a letter of credit. Yes, as I told you before, this is a very good choice for letters of credit. In all terms up to now, you have seen that we have the risk of the buyer hesitating to give us an onboard bill of lading, and in many cases we have talked about this. But in this case, because the seller is responsible for the carriage, and this is the seller who contracts the carriage with the shipping company, so the shipping company is under the seller's order, and you will not have such problem. Also, because all costs and details of the monetary issues are clear in CFR, the banks prefer this term for a letter of credit. 11. The Incoterm rules skip when title passes from the seller to buyer. This needs to be defined separately in the sales contract. In FOB, we talked a lot about the title pass, so it is important. Please review that part if you need to get more information.